Okay, let's talk about the brief a little bit so we're on the same page. I think there are different ways that we can show that she meets the statutory definition of refugee for purposes of asylum eligibility. I think, we definitely have a subjective and a subjective fear of persecution. It's objectively reasonable, as defined by the case law, that a reasonable person in her circumstances would fear persecution. The persecution that we're showing is, severe enough to constitute persecution,
Right.
As well as, severe abuse and harm. And then I'll get into the nexus.
Well, we should probably also talk about the objective fear, the factors that pertain to an objective fear of persecution as well.
Right, and I
Right.
think I cited those in the brief.
Right.
There are four
factors. Yeah,
okay,
there's
under matter of
Mogarabi.
Okay.
Right. That Fatima has a characteristic that the persecutor is
Seeks
aware
to-
of,
is aware
seeks
of.
to overcome by punishing, is aware of it, and is inclined and capable
of punishing. Definitely.
Okay.
I think, since we're showing that the persecution is by the government, we don't have to show that the threat is countrywide.
In other words, we don't have to show that she would have been safer moving somewhere else in the country. Okay.
Right.
Well, great.
And then in terms of the theories of persecution, I think we have a good case for her to be granted asylum based on past persecution alone under matter of Chen and the pertinent regulation, which I wrote down here, 208.13b12.
And that's interesting because one of the things we talked about earlier on in the case was whether what she suffered, specifically, the rape, would constitute persecution. So your research indicated that it would constitute.
There are published cases indicating that rape can constitute past persecution, as well as her detention and deprivations and punishment and torture in detention could constitute past persecution alone without a well-founded fear of future persecution. I think that's one basis. And as you know, we only have to show for asylum eligibility under Supreme Court precedent just a 10% risk of future persecution.
Right, a 1
so
in 10 chance.
A 1 in 10 chance of persecution. For withholding of removal, the companion remedy, which is mandatory, not discretionary, there we have to show an over 50% likelihood of future persecution, but I think we can meet that as well. I think the other thing I wanted to do that I did in the brief was really emphasize that the court should take notice and apply the children's asylum guidelines because she still is a child. The persecution that she suffered was as a child. These asylum guidelines are not binding on the immigration court. They're binding on the Department of Homeland Security in affirmative cases. But, the court can take notice of them and try to understand the persecution from the perspective of the child applicant.
And in addition to the children's guidelines or the gender guidelines, which I think would also apply in this
Definitely.
case.
If we're allowed to do an opening statement, we'll want to refer to the children's asylum guidelines as well as the gender guidelines and alert them to the sensitivity of the case.
Right.
We have great evidence to establish the past persecution theory, both the medical reports, which show the torture that she suffered, as well as the mental health report that has the diagnosis of post-traumatic stress disorder. So that's great objective evidence that's going to support the past persecution theory.
And the facts to prove chart was a good tool in coming up with, what evidence we want to use.
Yeah, and we do. We've got an abundance of evidence to present in this case. I don't know how we're going to do it in a one-day or a few-hour hearing.
Yeah.
In terms of, the theories that I thought, the big issue we're going to have in this case is, how it was persecution on account of one of the 5 enumerated grounds. So I wanted to go over with you sort of
let's go through each one.
Where I thought we were at. Okay. In terms of race or race, we could argue that she experienced and faces persecution by virtue of her racial background as a Malinke.
Right, her tribal membership.
Her tribal membership. You know, I'm not sure if the Malinke membership would be better to sort of include as particular social group, as a more discrete class, than under the rubric of race, but I do think we should try to argue it under race as well. And then in terms of religion, that's not relevant.
No.
Nationality, that's not relevant. So then we're into the land of political opinion. And I think we have both actual and imputed political opinion, because as you know, our client has attested, she has participated in political activities against the government there with the opposition party, and she has strong political convictions because of the opposition party. And I think that the government is aware of, you know, of her opposition, even though she never told her persecutors, I am opposed to you per se, but by virtue of her family membership as well as her Malinke membership, they are definitely imputing a political opinion to her that's contrary to, you know, President Conte's regime.
Right, especially since her uncle is such a prominent member of the opposition, and they are imputing his political opinion onto her as well.
Right. So I think, you know, in terms of the in terms of political opinion and past persecution, it'll be iffy to establish that it was her actual political opinion that triggered the persecution that she suffered.
Right.
It looks more like a case of imputed political opinion there. In terms of going back in the future and her future risk, you know, now that she's so committed to, you know, opposing the government and has demonstrated her opposition to the government, I think we have a case of, you know, that she would be persecuted based on her actual political opinion and her imputed political opinion.
And speaking of her family, that would also be a social group. I think we can also make the argument.
Yeah, there's great case law on family as a particular social group under asylum law. There are several circuit court decisions that stand for that proposition. So she was definitely being, you know, targeted and would be targeted because of her membership in, you know, in the family. One issue that could come up with that is that, you know, those cases really look at the nuclear family, and we have this issue with
extended family,
with the extended family and extended kinship, because, you know, it was her uncle, but her uncle is really kind of a distant cousin. So, but he was playing the de facto.
He was a father figure.
Exactly,
Yeah,
he was de facto father.
Right. I think we could make that argument.
Yeah, to carve it in terms of, you know, in an immediate family under social group analysis. Then in terms of discretionary factors, the issue that we're going to have is she did try to enter with a fraudulent visa. And that can pose some issues because under a case called Matter of Pula, which is a Board of Immigration Appeals opinion, you know, in absent any negative factors, discretion should be exercised for an asylum seeker. Now, the one factor that they cite as a potential negative factor is immigration fraud, entering with fraudulent documents.
But I believe they hold that entering with a false U.S. passport is severe fraud, whereas coming in with another country's travel document is not nearly as egregious.
Right.
And they make that distinction.
They make that distinction, but it is something that, you know, I think what we want to do with the fraud issue is really show that she didn't have the mens rea to commit fraud at the time that she entered. You know, that she was not even aware of the immigration papers that she was using when she was coming to the country.
Let me just make sure I'm clear on the whole discretionary aspect of this. Even if our client meets the definition of a refugee and satisfies all the elements for asylum, the judge still has discretion not to grant asylum. A number of factors could influence the judge's decision in that regard.
And that's why I've heard that some judges, it's much harder to get them to grant asylum, and you can get withholding of removal, which is a higher standard of proof, you know, more than a 50% risk of persecution. But that's mandatory. The withholding is mandatory. The asylum is discretionary, and some judges aren't as inclined to, grant asylum even with a lesser standard of proof because they don't want to be countenancing immigration fraud.
And not only would we have to meet a higher standard, but she would also receive fewer benefits from withholding of removal.
Yeah, withholding is not the remedy that we want in this case. I mean, if they were willing, one thing to think about, if they're willing to stipulate at the beginning of the hearing to withholding of removal, that's something we can consider. It's a risky proposition, but, I think all things being considered, we'd prefer to have asylum. She can then get a green card. She can become a U.S. citizen.
And I think that's really important for this client.
Yeah, I agree. Withholding is too tenuous a remedy.
Yeah, especially for someone that young. She could really make a future for herself here.
Under the discretionary factors, though, we have the fraud issue, but we've got a lot of really positive factors that I think we want to emphasize.
Such as her age,
Such as her age, such as the severity of the persecution, the continued treatment she's receiving with the psychologist that, wouldn't readily be available in Guinea if she returns. So, there are compelling humanitarian reasons for which she deserves a grant of asylum under discretionary factors. The statutory bars, I don't see any statutory bar for eligibility for asylum because she has no criminal convictions. She didn't participate in.
Quickly list them. There are criminal activity.
A particularly serious crime. If it's a particularly serious crime, that can bar you from eligibility.
Firm resettlement in another country.
Right. She came directly here, so we're okay. As well as participation in persecution.
That's clearly not an issue in this case.
Clearly not an issue. I think, the issues that are going to come up in terms of our legal theory with the Department of Homeland Security, I'm kind of concerned that they're going to just say that, this was a case of legitimate law enforcement activities, that they have a right to monitor the activities of opposition parties, and they took her in and interrogated her as an incident to legitimate law enforcement.
Well, luckily we have a number of reports that would kind of knock that argument right out of the water.
Such as?
Such as the State Department report that talks about the abuses that the government inflicts on opposition members, and it definitely doesn't in any way seem to condone what goes on in Guinea against the opposition. And our country expert will also testify that the conditions in Guinea, the actions against the opposition are just completely beyond anything that could be construed as legitimate law enforcement.
Yeah, the other thing I'm a little worried about is, as usual, is the nexus issue, because we always have to show with direct or circumstantial evidence that the persecution was on account of one of these protected grounds. With the Malinke issue, they were pretty clear that they were targeting her because of Malinke.
Right, okay. They were calling her Dirty Malinke and other insults and
that shows that the persecution
terms.
Was account of it. They were looking for her uncle, and her uncle was a political activist. That, I think, also evidences that it was due to her family relationship, as well as, imputed political opinion. And they did make allegations against her about, the Malinkis supporting the opposition effort.
Right.
So they did actually view her as a dissident by virtue of her Malinke membership, despite the fact that they apparently weren't aware that she had been going to these, different political functions. The other thing I'm concerned about is I've heard that the Department of Homeland Security now has been doing a lot of forensic testing of evidence, and we've got all of these original documents from Guinea, and we haven't had them tested to my knowledge, but I'm worried they're going to come back and say that they don't believe that they're legit.
Yes, and I did ask them about a month ago if they wanted to test these documents, and they said no, but they always have
really?
the option of seeing them, you know, in court and then saying, you know what, upon looking at this document, I'd like to have this case continued so that we can have them forensically tested. So we can hope that they don't do that, and we could object if they do, because we did give them an opportunity.
And
beforehand.
what's their legal authority to do forensic testing?
Well,
I thought
there is
there
a
was
regulation that discusses authentication, and it's based on that. And then, you know, since asylum cases turn so much on credibility, you know, documenting who a person really is and whether the documents they're producing are legitimate has become extremely important.
Do you think we need to try to get them tested?
I think we should look into that. I mean, there are organizations that do that. Yeah, but I did hear of one organization that does them at low cost. Then we can look them up and see if they'd be willing to do that.
Mm-hmm. And finally, you know, she is also eligible for protection under Article 3 of the United Nations Convention Against Torture. If she fears or has experienced torture at the hands of the government in her country.
That's similar to withholding under the Immigration and Nationality Act, right?
Exactly. It would give her the same benefits of withholding, which means that they just won't deport her and will allow her to stay, but they could always try to deport her at some time by rescinding the withholding. It's not a great remedy. I think, though, she does have a pretty good case for protection under the Torture Convention because the rape does constitute a form of torture that she experienced. And the benefit of Torture Convention is that unlike, you know, asylum and withholding where we have this nexus that we have to prove, it can be torture for any, you know, any illicit purpose.
As long as it's a government actor. Or government acquiescence. Exactly,
and here we have direct government actors. So, you know, it's just a backup remedy that I will also be prepared to argue, and I include, you know, her eligibility in the brief.
Okay, great.
So what else
well,
do we
have? Well, I think we should go through the direct examination. I can go see if she's here, bring her in, and we can get started with that.
Okay, great.